Welcome to our fourth weekly edition of Get More with Roar. This week we're going to be discussing another question that I get asked often here at the firm. Good morning, I'm Taj Roar of Roar Capital Management, and remember, the following is not financial, legal, or investment advice. It's for informational and educational purposes only. The question this week is, are executor and power of attorney the same thing? The answer is no. Let's take the first. What is an executor and what is their role? An executor is the person who administers a person's estate upon their death. The primary duty is to carry out the wishes of the deceased person based on the instructions spelled out in their will or trust documents, ensuring that assets are distributed to the intended beneficiaries. The executor has a lot of responsibilities. They are charged with making sure that all assets are accounted for, along with transitioning these assets to the correct party or parties. Assets that need to be transitioned include financial holdings such as investments, real estate, even collectibles or family heirlooms. When the process begins, the executor must estimate the value of the estate, either by using the date of death value or the alternative valuation date as provided by the Internal Revenue Service. In addition to distributing the assets, the executor also needs to ensure that all the debts of the deceased are paid off, including any taxes that might still be owed. The executor can be almost anyone, but is usually a lawyer, accountant, a family member, with the only restriction being that he or she must be above the age of 18, at least the age of 18 years old, and have no prior felony convictions. Being someone's executor is a huge responsibility. Now let's talk about the second, a power of attorney. A power of attorney is a legal document giving one person the power to act for another person. The person that gives the permission or the acting on behalf of is the principal, and the person receiving the permission is the agent or attorney in fact. The agent can have broad legal authority or limited authority to make legal decisions about the principal's property, finances, or medical care. The power of attorney is frequently used in the event of a principal's illness or disability, or when the principal can't be present to sign necessary legal documents for financial transactions. A power of attorney can end for a whole number of reasons, or at any time, such as when the principal dies, the principal revokes it, a court invalidates it, the principal might divorce their spouse, who happens to be the agent, or the agent could no longer carry out the outlined responsibilities. Conventional power of attorneys lapse when the creator becomes incapacitated, but the durable power of attorney remains in force to enable the agent to manage the creator's affairs, and a springing POA comes into effect only if and when the creator of the power of attorney becomes incapacitated. A medical or healthcare power of attorney enables an agent to make medical decisions on behalf of the incapacitated person. Thank you so much for again spending a few moments with me today. Next week, we will be answering the question, what is a fiduciary and why is it important that my financial advisor acts in this capacity? If you would like to get more information about us or meet with an advisor to evaluate your situation, call us today or check us out online through our website or Facebook page. Until next week, stay safe and blessed, and remember, get more with Roar Capital Management.